call this meeting of the PSRB to order. If everybody will state their appearances, starting with Mariah.
Mariah Westhoff.
Justin Trushansky.
Michael Finch.
Barbara Fields.
Matt McPherson.
I'm Micah Bruner. I'm acting chair in Abby's absence. Let's see. Did everybody have a chance to review the minutes from last meeting?
Yes.
Any changes necessary?
No.
I'll entertain a motion to adopt those minutes.
I'll make a motion to adopt the minutes.
Second. All those in favor?
Aye.
Aye. Opposed? I will abstain as I was not here last. We don't have any members of the public. So we'll skip reading the admonition, but we do have some business from the city attorney's office. So Eric, we'll turn the time over to you.
Thank you very much, Mr. Acting Chair. Eric Bunderson, City Attorney. From time to time, as use of force cases bubble up from the Supreme Court, Brad used to do trainings on those, and since he left, we've contracted with outside counsel to handle that portion. And today we have a case that we'd like to do some training on. We're going to record that and also present it to the police officers through their training system. And so I'd like to introduce Heather White. Now, I think when she did her last training, were you all here? Yes.
I was.
Yeah. Just as a reminder, Heather White has been working with West Valley City 25 years? 27 years defending us in various police civil rights lawsuits. She has seen it all from the early days of Jared Cardin pulling somebody out of a car to our most recent incidents. And so she is definitely the expert in this field, and we feel very safe in her hands as we discuss and defend ourselves on civil rights cases. So without further ado, I'll turn it over to Heather White.
Thanks, Eric. Thank you everyone for having me here today. I love being with you all. I can just say that I grew up with West Valley City and appreciate the opportunity to have worked with you guys for 27 years. It's where I grew up learning how to do civil rights cases, and it is my favorite thing to do, and I feel honored to be able to get to do it. As Rachel pointed out earlier before the meeting started, we have a lot of things going on with the current Supreme Court and administration, but we only have one case, fortunately, to discuss today with the Supreme Court and law enforcement issues. Earlier, last month, now we're in June, in May, the Supreme Court issued a decision called Barnes v. Felix. And they unanimously, strangely, but unanimously agreed on a new standard to be applied to excessive force cases based on the Graham versus Connor totality of the circumstances. There were different circuits that were interpreting particular Graham factors differently, most particularly the time to examine an officer's use of force. Some of the circuits were limiting the use of force analysis, the moment at whether deadly force was applicable, and all types of force, including deadly force, to just the moment that the force is used. And the Supreme Court said this is inconsistent with the Graham versus Connor ruling, which requires the courts to take into account the totality of the circumstances. And that means considering factors that lead up to the use of force. I think that's what we have been doing in the 10th Circuit for years. It's what we have been arguing at West Valley City and have been training for years. So this won't be a change in the landscape for us, but it did clarify, and I think rightfully so, that this, what was called the moment of threat rule, which was limiting just the circumstances at the precise moment an officer perceived threat is too narrow. And I think that's important for officers to remember as they are, these law enforcement encounters rarely happen instantaneously. They usually build and build and build where you start. A lot of times things will start as what seems like a routine call or even a consensual encounter, and they grow and they build. Sometimes they build more quickly than others, but sometimes through reasonable suspicion and then to probable cause. Sometimes they jump to the end, but I would say most often there is this building. And so as officers are taking a look at that, it's important for them to assess their actions as they're moving through. What am I doing? Am I escalating things? Am I taking actions that could be perceived as escalating by the suspect, by judges, by PSRB, those types of things. So in the Barnes case, I won't go over in great detail, but there was an officer who received a radio alert about an automobile on the road with outstanding violations, located that automobile, initiated a traffic stop, asked for license and proof of insurance. He didn't have it immediately available, said, I have it in the trunk. The officer asked him to pop the trunk, which he did. And as he did so, he started the car. The officer went immediately to the front and unholstered his gun, jumped partially into the car. And as it jumped into the door sill and ordered the car to don't move. He used some different language than that, but ordered the car not to go any further. And as the car continued to go, within a matter of 2 seconds, fired 2 shots, killing the driver of the car. And the Supreme Court did not rule whether the officer's conduct was reasonable under the circumstances or not. The sole issue before them at that moment was whether you consider the factors leading up the officer jumping into the car and putting himself in harm's way, which then necessitated the use of deadly force out of fear of imminent threat or of death or bodily harm, and sent it back to the appeals court for a determination, or it may have been back down to the trial court for a factual finding in determining what the facts were at the moment, and then whether under the circumstances that were reasonable. The court explained that prior events may show, and I'm going to read from the opinion, quote, prior events may show, for example, why a reasonable officer would have perceived otherwise ambiguous conduct of a suspect as threatening, or instead, they may show why an officer would have perceived the same conduct as innocuous. The history, the interaction, as well as other past circumstances known to the officer may inform the reasonableness of the use of force. And so it directed courts to quit applying the moment of threat rule and then to consider the entirety of the circumstances, returning that. Notably, as we talked before at our last session, the 10th Circuit applies the creation of threat. Did the officers create the need to use the threat? The Supreme Court recognized that some circuits are applying that rule, and if an officer by their actions increases the need for a use of force where otherwise it wouldn't have been necessary, that can weigh against an officer and can result in a finding that the officer's conduct was not reasonable. The court, recognizing those circuits, again, for the second time, in the last couple of years declined to reach that issue, whether that would be applied or not, because it was not before them. So that remains the law here in our jurisdiction because we are in the 10th Circuit and the 10th Circuit has applied that. So it's important for you to know that as you are examining officers' use of force, that still applies. And so taking those two into account, I think they're actually quite in harmony with one another, considering the totality of the circumstances. So I'm happy to email a copy of that decision to Eric, and he can circulate that among you all so that you have that as you make your decisions. And then I'm happy to answer any questions that any of you might have. It's a pretty straightforward case, but do you have any questions about what the ruling entails?
I guess I just have one question. When it comes to these, I know you said that this won't really change or impact how we operate in the city at least, but do you expect there would be any, depending on how, I guess, this plays out around the rest of the country, any changes expected to our policy, especially when it comes to low stakes encounters, and how we would deal with those when it comes to escalating and non-escalating sort of circumstances?
I think the city's policy on use of force and how it is to be, what is to be examined by the officers and considered then by administration in determining whether the officers have followed does not change with respect to this decision. I think it remains the same. You have instances, like I said, where you have maybe a consensual encounter that works up to maybe a reasonable suspicion and then into probable cause for arrest. Or you have something where you just arrive and immediately jumps to the need for deadly force. I mean, sometimes it can happen very quickly. As I was preparing for today, I was reviewing the 10th Circuit cases as well that have come down over the last quarter to make sure there was nothing there that I needed to inform you about. They're the typical decisions that have come down, just not changing any landscape in terms of how to analyze those. And so I don't see that any of the policy language that is incorporated into the city policy will need to or should change as a result of this opinion.
Will, like, if I could say what he was saying a little differently, like Los Angeles or New York, or will it affect how other police departments policies?
That's a good question. I don't know what their policies say. I would hope they would be generally consistent with ours. Don't we use Lexipol? Do we use Lexipol? And Lexipol is a nationally accredited, recognized standard, and they take the broad general standards that are applicable. And then if there are any local sort of twists that need to be added, they do that. But this is such a broad general proposition. I wouldn't think it would affect how actual policy. It's just how decisions are to be reviewed in light of whether it was reasonable or not under the circumstances. Does that make sense? So for example, our policy talks about the different levels of force ranging from, appearance right all the way up to lethal force. We have all these different options. And we've learned over the many years that we've been doing this, that there used to be this force of continuum ladder that they would have, that you would kind of have, that was perceived that they had to take one step and then move to the next and move to the next. And as encounters were examined, sometimes an officer walks up to a car and someone pulls a gun at him, and there's not the time or the ability or the need to walk through officer presence, verbal commands, non-lethal, less lethal force, those types of things. And so you jump to the immediate level of force that meets what the officers are confronting at that moment. And I think that's consistent throughout the country. So I don't see that's an example of how I don't see the policies necessarily changing, but it's in these circuits where the review has been based on just a very short moment versus taking into account what is happening leading up to it. Any other thoughts about the opinion or questions, how to apply it? The most important thing is how do we apply this, both from the officer's standpoint as they're out dealing with these encounters, and then you as you're reviewing them in determining whether they're reasonable or not.
Yeah, and that's what I was gonna ask is on the patrol level officers report, how would you suggest they articulate their use of force considering this case?
That's a great question, Eric. And it goes back really to the fundamentals that we've been talking about in police report training for the almost 30 years that I've been doing that. And reports are critical. It goes back to that report writing. And you mentioned the Cardin case, which was such an important case in demonstrating why report writing is critical, because we had a dash camera there and it captured most everything, but it didn't capture everything. It didn't capture everything that happened because of a delay in the camera turning on. It also doesn't capture things such as tone sometimes, intensity. It doesn't capture some of the body language. When an officer puts their hand on someone's shoulder, is it tense? Can they feel them start to move? The subtleties that are not. So the same principles apply, is that it's really critical for officers to walk through, as Officer Cardin did in that case, what happened, what they were doing, what they were perceiving, and why as they're going through. And it takes some time to do that. But with technology that we have now and the ability to dictate, I think that really we can encourage our officers to make sure that they are including all of the information that they can possibly think of that justified it. Because when I'm then standing up in front of a jury or you're reviewing their actions, we just are looking for what you did. What we kind of know, we know what you did based on the evidence, and there may be some gaps to fill in, but why did you do that? You know, what did your training tell you? I think it's really good if they can include things about, you know, the training, what maybe what they did in training in terms of just general training for officers at post, and then training that they've received from the city going through, or bulletins that they've read, those types of things. That helps us to understand why they're doing things. And then those subtle things that they are seeing and sensing when they are there on the scene in the moment, as opposed to us standing here in a room, you know, long after the fact, looking at things with 20/20 hindsight. Help us, I'm going to direct this directly to the officers, help us to feel what it was like to stand in your shoes at that moment. That's the simple way of putting it, so that we can better understand why you did what you did. Anything else? All right. Thank you, everyone. I hope you have a great day, and thank you again for having me with you.
Thank you. All right. I don't think we have anything else for the public portion of our meeting.
Motion to move to a closed session.
Second.
Motion and a second. All in favor?
Aye.
Opposed, abstaining?